The Support to the Institutional Reforms of the Constitutional Court project was launched at the Constitutional Court on May 24, 2023. The 18-month project is implemented by Europe in Law NGO with the financial support of the Embassy of the Kingdom of the Netherlands in the Republic of Armenia.
First and foremost, it is important to highlight that the Embassy of the Kingdom of the Netherlands in the Republic of Armenia was the first among international partners to recognize the significance of the Constitutional Court's institutional reforms and express interest in launching a dedicated project for the court. Cooperation between the Embassy and the Constitutional Court began in 2022 with a small-scale project, with the involvement of Europe in Law Association NGO, aimed at assessing the court's institutional needs. Following the identification of the needs, prioritizing continuous support to the Constitutional Court and sharing the stance of the Embassy of the Kingdom of the Netherlands on this matter, Europe in Law Association submitted a project proposal, aligned with the Embassy's objectives. As a result, on May 5, 2023, the project Support to Institutional Reforms of the Constitutional Court was officially launched. The primary goal of the project was to assist the Constitutional Court in strategic planning, enabling the court to develop its capacity to draft its long-term development strategies. I think this initial phase was quite a success, with a draft 3-year strategy of the Constitutional Court already completed. Stemming therefrom, an action plan for the first year is currently under development, which, once finalized, will be submitted to the Constitutional Court for approval alongside the strategy. Secondly, another key focus of the project was the development of ethics and integrity guidelines for Constitutional Court judges, which are now finalized and submitted to the court. Thirdly, the project also aimed to strengthen the professional capabilities of the Constitutional Court, which was achieved through the organized workshops and a study visit. Lastly, the project worked to enhance the visibility of the Constitutional Court and improve communication with various segments of the public. A number of activities were implemented in this direction to ensure that the Constitutional Court's activity is covered in a more user-friendly and understandable manner.
The project aims to support ongoing institutional reforms in the Constitutional Court, enhance the internal procedures of the High Court, and increase public accountability in the following areas: development, implementation, monitoring, and evaluation of a long-term strategy, revision and modernization of the ethics and integrity policy, capacity building in international law, including human rights law and constitutional law, enhancement of legal writing and research capabilities, strengthened communication and visibility of the Constitutional Court with the public, civil society, media, students, and both international and national partners. Along this line, a workshop was held on April 11 to 12, 2024 to develop the Constitutional Court's strategic plan for 2025 to 2027. During the workshop, the participants were introduced to the SWOT analysis model, reviewed general analytical data, engaged in brainstorming sessions, and discussed the key areas of strategic goals and the corresponding action plan.
The goal of the development strategy for the Constitutional Court for 2025 to 2058 is to ensure the most effective implementation of the Constitutional Court's constitutional mission. The document was developed through a participatory process, with input from a working group consisting of a Constitutional Court judge, the Chief of Staff of the Court, and an assistant to the judge of the Constitutional Court. The draft is very comprehensive, reflecting the issues that have emerged during these years as well as those identified by the staff of the judges and civil society that have been thoroughly analyzed and studied, being categorized into 5 main components. I would like to single out 2 since they have an external impact and dimension. The first issue identified is that of a communication strategy. Over the years, it has become clear that the decisions of the Constitutional Court sometimes require further clarification, particularly given the complexity of the issues they address. In this regard, the communication strategy primarily provides for recruitment of lawyers in the Media Relations Department of the Constitutional Court who will summarize the decisions of the court, put the constitutional issue solved by a concrete decision of the Constitutional Court into accessible language and present them to the public. In fact, it is a major challenge to summarize a Constitutional Court decision, simplifying it to a degree which would rule out the need for any other interpretation. On the other hand, while simplifying the language of the court's decisions is necessary, it is important to take into account that excessive simplicity could potentially misrepresent the scope of the court's decisions or extend their application beyond the position or understanding of the judges who wrote that Constitutional Court decision or voted for it. Therefore, it is essential to strike a balance between the simplicity of the judicial act, i.e. the decision of the Constitutional Court, on the one hand, and ensuring the correct legal solutions within this or that case, on the other. Hence, it would be necessary to collaborate with the media and lawyers to translate the court's decisions into clearer language, ensuring their accessibility to a broader audience. The second area I want to discuss is the monitoring of the judicial decision's execution. The recipients of the Constitutional Court's decisions include the National Assembly, the President of the Republic, and the courts of general jurisdiction. It is vital to not only communicate specific messages to these recipients but also to provide feasible solutions. Cooperation with the media will be crucial in this regard. For example, the Constitutional Court has ruled that the Supreme Judicial Council should provide explanations on the promotion of judges or appointments of court president. Hence, the media should help monitor whether the relevant recipients, such as the Supreme Judicial Council or the President, have. The project is a pivotal element of Armenia's ongoing judicial and legal reforms, which also stands as a successful example of cooperation between the state and civil society. I can confidently assert that this is quite an unprecedented development in the history of the Constitutional Court, where the vision of its development, and that of the judiciary more broadly, are based on a strategic framework. This means that an attempt is made to align both international and domestic legal advancements with a coherent strategic vision. In this context, as an assistant to a Constitutional Court judge, I was involved in a working group alongside a Constitutional Court judge, the Chief of Staff, and an international expert. Our objective was to assess the needs and requirements of the Constitutional Court in order to enhance the effectiveness of its constitutional functions and streamline its internal operations. We examined international best practices, reviewed dozens of preliminary decisions from the Constitutional Court, and analyzed internal documents, including employment contracts. The primary goal was to identify the most suitable solutions that would enable the Constitutional Court to achieve a new qualitative level of operational efficiency, particularly in areas such as document circulation, internal security, including information security, and improving coordination among various departments. Specifically, I focused on the relationship model between an assistant to a judge and the legal advisory department of the Constitutional Court, identifying key issues that need to be addressed. One such issue, in particular, had to do with an enhanced role of the assistants to judges, ensuring that this position holder is recognized as a person supporting the implementation of the judges' will, with the latter seen as a high-ranking official with a judicial mandate.
My name is Lucina Badalian, and I had the honor of preparing the development strategy of the Constitutional Court of Armenia for years 2025-27. This document is a framework for strengthening the Constitutional Court's role as the guarantor of constitutional justice and the rule of law. A well-defined development strategy is essential, as it ensures institutional resilience, enhances operational efficiency, and fosters greater transparency, and allows the court to address emerging challenges proactively rather than reactively. For Armenia, it is particularly critical today that the Constitutional Court strengthens its capacity to uphold constitutional values and reinforce public trust in a proactive manner. As the country undergoes institutional reforms and faces increasing public expectations regarding the judicial independence and national security, a well-defined strategy strengthens the Constitutional Court's ability to strengthen the country's standing in the international stage, prevent legal and political crises that could destabilize, promote legal predictability and stability, ensure balance of powers, independence and ability to withstand external pressure, raise trust in the judiciary, thus decreasing public tensions and reducing any potential civil unrest. The 2025-27 strategy is built on in-depth research and inclusive engagement. The development process was comprehensive and multidimensional, analyzing both internal and external challenges. We conducted interactive workshops with the court's personnel, in-depth interviews with the court's leadership, and direct consultations with the applicants and beneficiaries, gathering real-life insights on their expectations. Additionally, field research and comparative legal analysis and stakeholder interviews ensured that the strategy reflects both Armenia's legal realities and international best practices. The strategic plan focuses on key priorities: structural optimization, staff capacity building, enhancing the legal framework, and strengthening communication with the public. The court will also streamline case management, improve decision monitoring, and synchronize internal communication and enhance data security. By taking a deep, research-driven approach, this strategy ensures that the Constitutional Court remains independent, transparent, and prepared to meet the legal and societal challenges of the future. A strong Constitutional Court is fundamental to a strong democracy, and this roadmap will guide its development for the years ahead. Thus, the development strategy of the Constitutional Court of Armenia is not merely an administrative document, but it is a vital instrument for reinforcing the resilience of the state at all levels.
On January 26th to 27th, 2024, a workshop titled Domestic Regulations on Ethics and Integrity, an International Best Practice, was held with the participation of the judges and staff members of the Constitutional Court of the Republic of Armenia. The workshop featured invited speakers Esther Darui, Vice President of the Amsterdam Court, and Heikuhi Harutyunyan, former chairwoman of the Corruption Prevention Commission of Armenia.
Compared to other projects implemented so far, this project stood out due to the problems it identified, the solutions it proposed, as well as the results already achieved. It placed particular emphasis on corruption prevention and the development of codes of conduct for the Constitutional Court, making it unique in its approach. Historically, the Constitutional Court did not have formal codes of conduct or integrity rules beyond what was required by law, and no significant discussions had been held on this matter. With the support of the project, the judges and staff of the Constitutional Court were given an opportunity to visit the Netherlands, where they learned firsthand about local codes of conduct and anti-corruption mechanisms in higher courts. They observed how judges incorporate these practices into their daily work, how they interact with one another and with court staff, and how these mechanisms contribute to maintaining integrity. As a result of this experience, a workshop was held in Armenia, bringing together judges from the Netherlands and Armenia. This unique platform allowed both judges and staff to openly discuss crucial issues, including prohibition on taking gifts, code of conduct regarding conflict of interest, incompatibility, due respect principles, and professional conduct in legal case handling. The discussions of these rules helped the staff and judges to transform these theoretical concepts into a practical integrity guide which was integrated into the daily operations of the court, informing its activity and initiatives for enhancing integrity. The resulting Code of Conduct guideline became an essential component within the Constitutional Court's activity and internal operations. In essence, this deliverable serves as a practical guide for conduct, establishing a culture that not only governs the actions of the court's judges and staff but also influences other judicial bodies and high-ranking officials in Armenia through the localization of that culture across all institutions. These approaches and issues addressed by the project, in fact, ensured and strengthened corruption prevention, fostering an integrity culture at a high institutional level, with both judges and staff becoming the practical advocates and bearers practitioners of these principles.
2 years ago, together with Luzine Hakobian, President of European Law, I started my first tour through the Constitutional Court. And after conversation with many of you, as well as with the leadership, we decided to propose the court to focus on 3 topics. First of all, on integrity. We started a workshop on guidelines for integrity and talked about certain issues that are relevant, like conflict of interests and gifts. After that meeting, guidelines and rules were written, and we will discuss them in April. Later, we had a very pleasant meeting in which I tried to give you an insight on the way of internal communication in my court. And of course, due to a different culture, it must have sounded somewhat peculiar for you sometimes. For instance, when I talked about the cascade communication, like the way the water comes down in a waterfall. In the evening, in the bar of the conference venue, I had the pleasure to talk with many of you about the rule of law in Europe. Last year, I was happy to receive a delegation of you in Amsterdam. I could show you my court, as well as some of our institutions in The Hague. And the meeting was concluded in Amsterdam in a typical Dutch industrial restaurant. I will be in your court again in April. I'm looking forward to that very much, to see you again, to talk with you, and to hopefully carry out nice activities for internal communication and integrity.
The law on public service defines each of the elements of integrity in this sector independently with its own content, and separate articles are drafted for each of them. These include the principles of conduct of persons holding a public office and staff members in the public service sector, as well as the rules of conduct stemming therefrom, such as rules on accepting gifts related to official duties, conflict of interest regulations, incompatibility requirements, and other restrictions. The relevant provisions in the constitutional law on the Constitutional Court follow a totally different logic. Specifically, Articles 14 and 15 are based on a different logic, emphasizing the judge's code of conduct and outlining separate rules under the broader framework of judicial conduct. Essentially, the law on public service can be viewed as a collection of standalone elements in the broader system of integrity. For example, a judge's obligation to avoid cases leading to conflicts of interest or situations of the kind. Additionally, among the judicial rules of conduct, the constitutional law includes provisions on declaring property, income, interests, and expenses. In this regard, a separate article provides for restrictions on accepting gifts related to fulfillment of official duties. By the way, the restrictions are meant as a standalone rule of the Code of Conduct. In any case, it should be noted that there is a need to organize and systematize these rules. For this reason, it is essential to consolidate the regulations governing the integrity system, provide further details, and make them accessible in an appropriate guide. The development of such a guide could promote ethical conduct and thereby help prevent any possibility of unethical conduct within the institution.
In March 2024, the representatives of the Constitutional Court of Armenia undertook a study visit to the Kingdom of the Netherlands to acquaint themselves with the Dutch judicial system. The delegation included Deputy Chairman Vahe Gregorian, Judges Seda Safarian, Edgar Shatirian, Advisor to the President Alina Frikian, Head of the Expertise Analytic Division Aida Tadavosian, Head of the International Treaties Department Dora Kachatorian, and Assistant to the President Ardak Gazarian. During the visit, the participants toured several key institutions, including the Council for the Judiciary of the Netherlands, the State Council of the Netherlands, the International Criminal Court, the Court of Amsterdam, and the Supreme Court of the Kingdom of the Netherlands.
2024 թվականի մարտ ամսին Սահմանադրական դատարանի պաշտոնական պատվիրակությունը
In March 2024, I had the privilege of being part of the official delegation of the Constitutional Court to visit the Kingdom of the Netherlands. We were warmly hosted by various state bodies, particularly judicial and state councils, courts, and the Amsterdam Court. A judge from the criminal chamber of the Supreme Court of the Netherlands welcomed us as part of the visit. During our discussions, the role of specialized bodies of constitutional justice was highlighted in the context of preserving the constitutional identity of states. Additionally, we visited the International Criminal Court, where we were hosted by one of its judges. I believe the visit was highly productive, as discussions within all the organizations were mutually helpful either to explore new avenues of cooperation, initiate new partnerships, or deepen existing collaborations. Both sides demonstrated genuine interest in strengthening bilateral relations. I highly value such visits and meetings, as they may contribute to the continued development and deepening of our bilateral relations.
As part of the project, a delegation led by the Vice President of the Constitutional Court traveled to the Kingdom of the Netherlands in March 2024. The delegation included judges from the Constitutional Court and staff members. During the study visit, the delegation first visited the State Council and the Judicial Council of the Kingdom of the Netherlands, where they learned about the mechanisms and procedures for holding judges accountable through disciplinary measures. The delegation also visited the Amsterdam Court, where they met with local judges. A key highlight was the meeting with the judge responsible for public relations, who shared their experience in this field, particularly focusing on ways of making the court more accessible to the public. The visit to the Supreme Court of the Kingdom of the Netherlands was particularly engaging, offering a two-way exchange of experience. Given that the Kingdom of the Netherlands is part of the Nordic law, with no specialized constitutional oversight bodies, our counterparts expressed keen interest in the workings of a constitutional oversight body, as is the Constitutional Court in our legal system. Our delegation described how constitutional oversight bodies, specifically constitutional courts, operate within our system, facilitating a fruitful exchange of ideas and practices.
Մասնագիտացված մարմինները, սահմանադրական դատարանները։
On December 4th to 5th, 2024, a workshop titled Workshop on Legal Writing and Research for the Constitutional Court and the Court of Cassation of the Republic of Armenia was held in Sarkadze. The workshop featured lectures from Dr. Gorjan Petrosyan, a lecturer at Friedrich Alexander University of Erlangen-Nuremberg, and Judge Joanna Korner of the International Criminal Court. On January 15th to 16th, 2025, a workshop titled ECHR Standards and ECHR Case Law was held in Sarkadze. The workshop was led by Philip Leach, the former director of the European Human Rights Centre, ERAC, a member of Matrix Chambers in London, and a professor of human rights law at Middlesex University.
Several events were organized as part of the project, two of which I would like to highlight. The first was a research and practice session, focusing on the development of legal writing and legal research skills. During this event, important skills were shared and critical discussions were held, featuring Joanna Korner, an acting judge at the ICC, and Gorjan Petrosyan, a lecturer at the University of Nuremberg. The session was attended by judges of the Constitutional Court as well as those from the Court of Cassation, assistants to judges of the Constitutional Court, and staff members. Enhancing their expertise in this area was of major importance. The second event addressed current issues in the case law of the European Court of Human Rights, ECTHR. This session was led by Philip Leach, a distinguished expert on ECTHR case law and the European Convention on Human Rights. Professor Leach, a law professor at Middlesex University in London, has submitted hundreds of cases to the ECTHR and authored numerous textbooks on the subject. His presentation, followed by engaging discussions, provided invaluable insights for the judges of the Constitutional Court and the Court of Cassation, enabling them to stay updated on the latest developments in ECTHR case law.
On December 13, 2023, the first working meeting between the High Court and civil society representatives took place at the Constitutional Court's administrative building. The meeting aimed to foster dialogue between the Constitutional Court and civil society organizations, while also outlining the terms of future cooperation and identifying areas of mutual interest. The second meeting was held on February 7, 2025.
Armenia is an independent state with an executive and a legislative branches of power and judicial institutions. As we work towards building a democratic country, cooperation with NGOs, experts, and the relationship between the society and these state institutions becomes essential. The more active this cooperation is, the more democratic our society can become. The Constitutional Court holds a crucial role among judicial bodies, and the connection with experts, NGOs, along with the understanding of the Constitutional Court's functions, its tasks, and operations are vital. In this context, I highly value the work undertaken by Europe in Law NGO. This NGO, quite well known in Armenia and led by Lauzena Hakabayan, has initiated an excellent format for engagement, organizing meetings between the representatives of the general public, experts, and members of the Constitutional Court. These meetings help to further clarify the rights, tasks, and opportunities for both experts and the public, allowing Constitutional Court members to better understand the sentiments in the society. In today's rapidly changing and turbulent world, many questions are raised by initiatives in the Republic of Armenia. For instance, do the laws adopted in the National Assembly align with our constitutional norms? This cooperation becomes particularly crucial in addressing such concerns. The Constitutional Court as an institution plays a significant and continuously enhanced role in this. However, as representatives of the society, we hope that the Court's decisions will adequately address the challenges we face. I would like to reiterate my appreciation for Europe in Law NGO's initiative in this area. Projects and initiatives of the kind, including meetings with the Constitutional Court and training on its practices, should be encouraged. Even those of us with extensive experience in the field have much to learn, and it's especially important for youth organizations and new initiatives to better understand the Court's role and functions. Since the constitutional amendments of 2005, we know that not only political parties or state institutions, but we as citizens too enjoy the right to directly apply to the Constitutional Court. Hence, this opportunity shall be taken an advantage of to strengthen democracy in Armenia.
On July 29 to 30, 2023, the first summer school organized by the Constitutional Court took place for senior law students from Armenian universities, namely with the participation of students from Yerevan State University, the American University of Armenia, Eurasia International University, the French University in Armenia, and the European University of Armenia. The summer school featured lectures by Constitutional Court judges Hovakim Hovakimian, Edgar Shatirian, Seda Safarian, and its Vice President Vahe Grigorian. The second summer school was held on September 7 to 8, 2024, in Sarkadze for senior law students from universities across Armenia. The lectures were delivered by Constitutional Court judges Seda Safarian and David Kachaturian, its Vice President Vahe Grigorian, and human rights lawyer Ardak Zainalian.
Within the framework of the support to institutional reforms of the Constitutional Court project, the Constitutional Court initiated and, with the support of the Embassy of the Kingdom of the Netherlands and Europe in Law NGO, implemented the Summer School on Constitutional Law. This initiative provided an excellent opportunity for students from almost all law departments in Armenia to familiarize themselves with the internal procedures of the Constitutional Court and engage in direct communication with the court's judges, which naturally makes the institution more accessible and comprehensible to the younger generation of legal professionals. It was a great honor and pleasure to participate in the summer school organized by Europe in Law NGO within the framework of the support to institutional reforms of the Constitutional Court project. The school provided a unique opportunity to acquire new knowledge, participate in professional discussions, and develop legal thinking. During the summer school, we explored numerous legal issues, with particular attention paid to the role of journalists in shaping people's legal understanding. Special focus was given to democracy, the separation of powers, the protection of fundamental rights and freedoms, and the impact of journalistic coverage on these areas. The school allowed us to engage in interactive discussions, analyze specific constitutional cases, and raise interesting questions and issues. The interaction with leading experts, lawyers, and professors in the field was particularly valuable. Through their experience and knowledge, they contributed to enriching our jurisprudential perspectives. The summer school was an invaluable experience in terms of both professional development and personal growth. It not only deepened my understanding of constitutional law but also provided new approaches and ideas regarding law and public administration.
In September 2023, a training course titled Media Coverage of the Constitutional Court's Activity was held at the Constitutional Court, with the participation of journalists from various media outlets who cover legal topics. 2 thematic sessions were organized, featuring speeches by the Constitutional Court Vice President Vahe Gregorian and Chief of Staff Samvel Arakelian.
One of the key components of the support to institutional reforms of the Constitutional Court project is a series of activities aimed at improving public communication, particularly working with media representatives. This is an area the importance of which cannot be overstated in terms of ensuring transparency in the activities of any state institution, as well as securing public accountability. With the support of the Embassy of the Kingdom of the Netherlands in Armenia and in partnership with Europe in Law NGO, the first meeting with journalists covering legal topics was organized at the Constitutional Court. This was, of course, an interesting and highly important experience for both sides. This format of cooperation with the media provides an opportunity to support journalists covering the legal sector to more effectively report not only on the activities of the Constitutional Court but also on legal issues in general. Such knowledge-based events contribute significantly to the reinforcement of the concept of responsible journalism, providing journalists with the opportunity to collaborate more effectively with judicial bodies, make their inquiries more targeted, and ultimately fulfill their mission, which is also to serve as an information channel and bridge between the public and government institutions for full and objective delivery. On the other hand, feedback from journalists is crucial for state institutions, as sometimes media partners highlight issues that are not visible within the institution, which can be either of substance or even of minor technical significance which do not take the authorized body much effort to resolve, yet can significantly ease journalists' work. And the primary beneficiary of this entire process is, of course, the consumer of information. Given the unprecedented pace of information advancement today, the transformation of communication formats within and among state bodies is inevitable. Its successful implementation is especially crucial in the field of constitutional justice, which is the primary focus of the activities carried out.
In line with the objective for ensuring strengthened communication and visibility of the Constitutional Court with the public, civil society, media, students, and both international and national partners, the Europe in Law NGO produced a series titled Explanations on Constitutional Court Decisions. 8 episodes have been produced with Constitutional Court judges providing insights into key decisions made by the court on topics of major significance.
The second phase of the project commenced on February 1, 2025, which both the Embassy of the Kingdom of the Netherlands and Europe in Law NGO will regard as a transitional phase. This means the Constitutional Court will ensure sustainability of effort moving forward in areas where the court enjoyed project-based support by the NGO. In other words, if the project has assisted the court in making its decisions more accessible by explaining and clarifying them through public reports, it is expected that the court will subsequently be able to continue this activity independently. Similarly, the implementation of strategic planning, identification, and enhancement of staff capabilities, maintenance of communication practices with NGOs and the media well established within the project, along with sustaining and developing the summer school for students will be expected, too.